Hey Nick, how you doing?
I'm fine, thanks, and you.
Good, good.
Good. So, another episode of PLA. We've got questions today. What I'm going to do, Bruno, is I'm going to ask you your question in two sort of parts because they're similar sort of
Sure.
circumstances, but just a little bit tweaked on the facts. So, what we've got is our writer in it says that they've got a tenant who's overstayed their lease. Okay, so the lease is terminated by a fraction of time. They've overstayed that period, but they are still paying monthly holding over damages. Okay, in respect of that particular premises. Now, one of the toilets has stopped working in respect to the premises. And the question is, does the landlord have an obligation to fix it, or is that now a tenant's problem in respect to that particular lease? And then there's a second part to the question is where we take a little bit of a different scenario and we say, uh, what if we have a tenant who's still in place in respect of a premises in terms of a lease agreement? Okay. And there is some damage on the premises that needs to be attended to, but the tenant is not allowing the landlord access during the week in order to attend to the premises. They are insisting that the tenants or that the landlord or their contractors only come in on weekends, which is obviously a difficulty for the landlord in the circumstances. The question is the tenant, by virtue of the fact that they're not allowing access, liable for any damages that they cause as a result of the problem that's not getting fixed?
Sure. Thanks so much, Nick. The question often arises in lease agreements when it comes to the landlord's duty to maintain and repair. Now, let's assume under all these circumstances that the landlord actually carries a duty for these repairs, in the sense that there are things that the landlord would customarily attend to, right, for some reason or another. And this is normally when you're looking at structural issues or issues that weren't caused by a tenant damaging something or other, right? Now, so as an example of this, you'd find that issues in the ceiling are commonly repaired by landlords. You'd find that plumbing issues, electrical issues, all of these things would typically be repaired by a landlord. Now, in residential and commercial, the same typical rules would apply. You'd look at the lease agreement, see what the landlord carries obligations to repair. Now, these questions are more around when can a landlord deny certain repairs? And even though they're obliged or obligated to effect these repairs, when can they deny making these repairs? Now, there's a lot of examples, but we commonly find some scenarios. And these are two scenarios that we've seen recently. So, on the one hand, there's a scenario where the tenant isn't actually supposed to be on the property. Tenant's not supposed to be there at all. And we get this very frequently, and it often creates issues with between the tenant and landlord, because, for example, if there's a plumbing issue and you need to disconnect water, the tenant now feels that they're being alienated and pushed out of the property, when meanwhile the landlord might not even want to fix it at that moment in time, may actually want to push these repairs on to another period of time, but now the tenant is there, but is there unlawfully, and is now trying to force a landlord to fix a property that he's not supposed to even be on. And is the tenant obliged to fix it? No, he's not obliged to fix it. The difference in this particular question is that this tenant continues to pay what's called holding over damages. Now, holding over damages is basically another way of saying rent, but not without the consent of the person staying there. So rent a person pays when they're in occupation of the property and they have consent to stay on the property. Holding over damages is basically what they pay to compensate a landlord for staying on the property even though they're not supposed to. So, for example, if you go to an attorney and you say, go sue for rent, I canceled the lease a year ago and they're still staying on the property, please remember, rent gets claimed during the period that the lease was valid. After the lease is cancelled, you claim holding over damages. Might be the same amount, but it's given different names because the one carries the connotation of consent and the other one doesn't. And this is very important in our law, because if you're giving them consent to stay on the property, then it goes back to a relationship, a lease relationship, and then you need to follow the right paths again in order to terminate and do the rest. So you don't want to keep invoicing rent and that sort of thing. But in any case, now we're having a conversation to say that this person is paying holding over damages and is claiming that there be repairs to the property. Now, again, this is an opinion thing because there isn't a lot of case law on this, but my opinion here is that you've got no obligation. They're staying on the property, they're not supposed to. They're welcome to move out the property. They're paying holding over damages, knowing that they're staying on the property unlawfully. And as long as you're not accepting this as rent and you insist that they move out of the property, as far as I'm concerned, there is no contractual obligation on you as a landlord to effect any repairs. And this applies to commercial, this applies to residential. Now, in another example where a landlord is refusing to attend to repairs of the property, and this is quite a common one, especially in commercial properties, but also happens in residential properties, is when the tenant cannot make provision, is not available for these repairs to actually take effect. So in residential, you find, for example, the tenants don't want to take off work, so they're only available over weekends, but contractors aren't available over weekends. In commercial, even worse, because commercial, they're constantly trading. So if the repairs take longer than a day, you find the tenants are insisting or demanding on a repair, but they're trying to set their terms on how this repair is going to take place because they want it to impact their business as little as possible. Now, you as a landlord have to be mindful of this and have to do as much as possible to try and cooperate. But if the situation arises where it's simply not possible, where it's going to cost a huge amount extra to try and get somebody in either over a weekend or to break up the type of work where you have to tile, retail over and over just so business can continue, you as a landlord are not obliged to do this unless the lease agreement obligates you, which isn't usually the case. So you need to effect the repairs. You need to do them with the least amount of effort, but in the best quality that you can. More than this, it becomes the tenant's responsibility. If the tenant's not available over the weekend, sorry for the tenant. If the business is going to get disrupted slightly because of repairs to the property, I'm sorry, but there's very little that can be done as long as you're acting reasonably. If the tenant wants more, by all means, but then it should be the tenant's obligation and responsibility to cover any additional costs simply for its own convenience.